Hi, welcome to Daniel Cross Talks. My name is Daniel Cross, and today we begin with a development that analysts, legal commentators, and political insiders had feared, tracked, and reluctantly acknowledged. A decision that unfolded not over years of debate, but in a matter of days, days that forced a former president into a courtroom spotlight, days that reshaped narratives about accountability, days that made even seasoned observers sit up and take notice. What Donald Trump did today crossed a line that many in legal circles had hoped would hold firm. And when that line broke, the judicial system did not hesitate. They responded with clarity, precision, and firmness, an unmistakable message that the wheels of justice can turn even when the subject of scrutiny is a figure of immense political stature. For many months now, there had been signals, not official press briefings, not formal announcements, just motions, filings, and appellate strategy shifts, that something significant was brewing. Trump has been defiant, yes, but he has been aggressive in defending himself. His moves have followed a pattern, a repetitive stance, almost a playbook of trying to shift battles out of the public eye and into procedural arguments. But what set off alarm bells in legal circles this time was that the usual pattern went silent right before a major procedural hearing. Experts who monitor these unfolding legal dramas know the indicators. Sudden quiet from a usually vocal defense team, a lull in statements, and a pause in public filings that almost always means something consequential is about to break. And whenever Trump goes quiet, it means something is about to get loud. Early in the day, a New York State appeals court delivered what many are calling a defining legal shift, upholding a lower judge's ruling that former President Donald Trump must answer questions under oath in the New York Attorney General's civil investigation into his business practices and the valuations of his properties. A four-judge panel in the appellate division upheld Manhattan Judge Arthur Engoron's ruling enforcing subpoenas, requiring that Trump and his two eldest children give deposition testimony in Attorney General Letitia James's probe. This is not the kind of move a major legal figure undertakes lightly. These are the kinds of judicial orders reserved for when a civil case has reached a critical point, when evidence meets the threshold for further examination, when avoidance tactics no longer shield defendants, when the court determines that compliance is necessary to advance justice. Observers didn't know which category this would ultimately fall into, whether it was procedural pushback, a strategic retreat, or an outright turning point. But what they did know was that the legal strategy had changed, and when a major figure shifts strategy without explanation, even by a small measure, authorities pay attention. The response issued by the legal authorities today was not normal. It was not routine. It was urgent. Legal commentators, after the appellate panel's decision, described Trump's move as decisive, unprecedented in this context, and legally unpersuasive. But legal strategy only works if the target, in this case, Donald Trump, hesitates. He did not. In fact, the appellate ruling today was among the most consequential we've seen in this high-profile civil case. Within hours of the appeal being heard, the appellate panel upheld a decision that Trump must testify under oath, not loosely suggested, not softly encouraged, but as a binding legal obligation. These weren't ordinary subpoenas. These were enforceable judicial commands backed by an appellate panel that said clearly and legally that compliance was required unless further intervention occurred. Tonight, available sources confirm that the appellate division upheld Judge Engoron's ruling, requiring deposition testimony from Trump and his two eldest children. This is significant because it rejects the core argument from Trump's legal team, that civil testimony would expose the former president to risks in parallel criminal investigations and therefore should be blocked. The appellate judges made clear that the existence of a criminal investigation does not preclude civil discovery of related facts and that witnesses can always exercise their constitutional privilege against self-incrimination where appropriate under federal and state law. This is what made today's decision so urgent. Trump's legal push wasn't just symbolic, it was actionable. It represented a definable legal threshold that must be confronted. And the court, understanding that fully, responded, not recklessly, not impulsively, but with legal precision. They didn't vacate the subpoenas. They didn't delay compliance indefinitely. They affirmed the rule of law, that civil subpoenas issued in a legitimate investigation are enforceable, even when the subject of that subpoena is a former head of state. And here's where the story becomes even more consequential. Legal analysts now believe that Trump's latest procedural maneuver was designed to test the boundaries of civil discovery in a politically charged environment. His attorneys argued that answering questions under oath now could expose him to legal jeopardy in jurisdictional areas outside the civil claim. They suggested that civil deposition might be used as a backdoor to evidence in a criminal context. But the appellate division firmly rejected that reasoning. They stated that civil and criminal investigations can proceed in parallel, and that the mere existence of one does not exempt a party from compliance in another. This has broader implications, not just for this case, but for how high-profile defendants engage with multifaceted legal challenges. You don't win attention from appellate judges easily, but today, Trump did. Legal observers describe the court's decision as a reaffirmation that legal procedures apply equally, regardless of political influence or historical reputation. This decision matters because it signals a judicial willingness to uphold subpoenas and to insist on testimony under oath, even when constitutional concerns are raised. As the day's reports rolled in, we learned more about the scale of the ruling. The appellate panel confirmed enforcement of the subpoenas. It dismissed the constitutional avoidance argument, and it stated that the subpoenas were grounded in a legitimate civil fraud investigation that has been ongoing for years. Attorney General Letitia James's office, which has been investigating whether the Trump Organization used fraudulent or misleading property valuations to secure loans and tax benefits, sees this decision as vindication of their legal process. At the same time, Trump's legal team said they may seek further review from New York's highest court, the Court of Appeals, meaning this battle could continue. But for now, the intermediate appellate decision stands, clearing the path for deposition testimony that Donald Trump must provide unless a stay is granted. Remember, legal strategy is not just about the arguments you make, it's about the stakes that underlie them. Trump has fought this civil investigation from the start, calling it politically motivated and dismissing the allegations. But today's ruling makes it clear that courts are not prepared to let such assertions override enforceable legal procedures tied to investigating potential civil wrongdoing. What makes this moment so intense is that it comes at a time when Trump is facing pressure on multiple fronts, politically, personally, and legally. This isn't just about a civil subpoena in New York. It's about how someone with immense influence navigates accountability within the American legal system. Trump's opponents have long argued that no one is above the law. Today's decision gives weight to that principle. In response, the Attorney General's office issued statements emphasizing that compliance with lawful investigations is fundamental to the rule of law. Officials made it plain that Trump's efforts to block or delay his deposition were unjustified. That is judicial language for, you do not get to pick and choose when you show up for testimony just because you are a former president. Trump's legal team, meanwhile, reiterated that they disagree with the appellate ruling and may appeal, but the decision for now stands. The public reaction has been intense. Supporters see this as part of a larger political fight, while critics say it reinforces that accountability operates even at the highest levels. Tonight, what we're watching is a test of legal resilience. Trump wants to see how far his constitutional and procedural defenses can be extended. The judiciary wants to affirm that legal process matters. Attorney General Letitia James wants to pursue a civil fraud case that has spanned years, and the public wants transparency. Events are still developing, but here's what we now know. Trump's deposition is scheduled unless a higher court intervenes. His attorneys are reviewing the ruling and exploring legal avenues. And the judicial system has sent a message that, for now, compliance with civil subpoenas is not optional, even for someone who has held the highest office in the land. As this story continues to unfold, expect more details about what exactly Trump hoped to achieve with this latest appeal. But the appellate decision has already clarified several things. It reinforces accountability. It underscores that the civil legal process remains operational, and it places pressure on all parties involved to confront the next phase of this legal drama. And tonight, for many watching, this moment feels like a turning point. The courtroom is quiet. Too quiet. And when legal proceedings go quiet, it often means the next strategic move is being plotted. Because today, Trump and his legal team learned something critical. The rule of law can press forward, and judicial decisions carry consequences even for former presidents. This story is far from over. But one thing is clear. The legal process has taken another significant step, and we will be here watching every detail as the next phase unfolds.